Your employer can no longer just transfer you to a position you don't want and claim it's okay because you're keeping the same salary. A Supreme Court decision yesterday makes it easier for workers who are transferred from one job to another against their will to pursue job discrimination claims under federal civil rights law. Analysis from employment attorney John Bell, founder of Bell Law Group in New York. John, give us the basics.
Specifically deals with job transfers, which we get those calls often, and they're normally defended by the fact that the employer claiming that there was no adverse action taken because the employee that was transferred to a new role is at the same pay and grade level. So because there's no adverse action, the claim of discrimination fails because there's no damages. But what the Supreme Court did was basically reverse that logic with respect to their defense in claiming that now it's not just the pay, you have to look at the actual circumstances. For example, if the transfer was now from a daytime position to the night shift, even though they pay the same, it doesn't matter. For example, in this specific case, it involved a St. Louis police sergeant where she was working for 9 years in plain clothes in the intelligence unit, and she was transferred to a uniform position where she supervises patrol officers because the new wanted to work with a male. And although the lower court dismissed that case based on the fact that there really was no adverse action because her pay didn't change, the Supreme Court went ahead and reversed the lower court's decision. So now that case is going to be going back to the lower court and basically resuscitated a case that was ultimately dismissed.
Wow. All right. So this is sort of like, like a passive-aggressive demotion almost?
Exactly. They're just making the circumstances of the job less tenable. Transferring someone to a night shift or transferring to a different location where the person has now a longer commute or maybe a less prestigious job, a different place in the building. Maybe they used to work in a nice third floor, now they got transferred to the basement, and the employers used to be able to use that as a defense, saying, yeah, you might claim it's because of your gender, however, there was no adverse action. Your pay is still the same.
Wow. We're speaking with John Bell, employment attorney and founder of Bell Law Group in New York. We're talking about this Supreme Court decision Wednesday, making it easier to sue for job discrimination when you've experienced a forced transfer. So the police one is kind of an easy one to digest, I guess. Are there other examples where this might apply?
So fortunately, this applies, doesn't matter what your position is. Normally when someone complains of some type of discrimination or harassment and you want to separate the two, you would want to go transfer the person who allegedly caused the discrimination. But once employers transferring the actual employee who complained, which can be viewed as retaliatory, and then they would use this defense saying, listen, it's the same pay, there's no adverse action here. So this allows a claim like that to continue. So, yeah, the police officer was a perfect example of someone being punished where there may not be apparent on paper, but in reality there is some form of punishment there.
Yeah. So it's like the case has to be taken in totality or in its entirety, like a view from 30,000 feet under this forced transfer.
Basically, yes. That's a very good way to describe it. You have to look at the totality of the circumstances. It's not going to be as easy as, okay, this person now is getting paid less, or there was a suspension involved, or a termination involved. You have to look at the facts behind the transfer. Can it be argued that the transfer was actually fits within the adverse action description?
Thanks, John. John Bell, founder of Bell Law Group in New York. 20 minutes now in front of the hour on This Morning, America's First News. Hey, it's Gordon.